The matter before the court now is Penobscot 23-461, State of Maine versus Angelena Quirion. And if counsel would identify themselves by saying their names for the record, together with the party he represents, starting with the appellant.
Thank you. Good afternoon. Rory McNamara for the appellant, Angelena Quirion.
Good afternoon. Jason Horn on behalf of the State of Maine.
Thank you. And as is usual, we are being streamed live on the web, both by video and audio these days. If you are ready to proceed, Mr. McNamara would be happy to hear your argument.
Thank you. May it please the court, counselor.
And I note that you decided to not protect any time
That's
here,
right.
so I'm going to take advantage of that.
Right.
Let's assume you're correct and that there is evidence to support the statement that was made by counsel in the closing about the possession of the Walmart bag.
Mm-hmm.
I think there is.
Yep.
Is that really to sustain an objection? How is that a comment on the evidence?
I'll give you two cases where this court has held it was a comment on the evidence to sustain an objection, to rule on an objection. The first one is State v. Linnell, which is 408 A2D 693. It's a 1979 case. There, the issue was whether or not the defendant could act in self-defense. The trial court sustained the prosecutor's objections, saying when the defendant was testifying, the defendant was asked something along the lines of, do you think you could have stopped him without using self-defense? And the trial judge, following the prosecutor, said, no, that's mere conjecture that you could do that ruling. Because of course it was evidence that was being offered by the defendant. So that's one example. A second example is State v. Varney, 641 A2D 185. There, the court overruled the state's objection to certain defense evidence. The judge said, oh, I'm going to admit it, but only for its marginal relevance. In that case, the law court didn't reverse, but it said that was an improper comment on the evidence. It didn't reverse only because it didn't deal with a controverted fact, so it didn't fall within the statute precisely. And it turned out, so harmless error applied, in other words, to that particular comment.
And that was going to be my next question.
Correct.
Is assume we say, well, that's sort of a comment on the evidence. Does the statute require us to vacate at this point without regard to any analysis as to harmless error, as to whether the later instruction with regard to who makes the decision as to whether it's up to the jury to decide what the evidence is and what the evidence means, any of those things that we would normally, an analysis we would normally engage in other
Normally consider,
circumstances.
correct. And I'll answer the question both ways. And I do think that structural error applies. I think that is the language of 1105. It is sufficient cause by itself for a new trial if either party aggrieved thereby interest desires it. So that's point number one. I think in the Kessler decision, that is kind of the inclination. It says as long as there is a comment on a controverted rather than an uncontroverted fact. So that's where it's almost like a quasi-baked-in harmlessness analysis. If you think everything about uncontroverted facts is going to be harmless, and then those things about controverted facts are not going to be harmless. They fall within that statute. The third point is the state hasn't disagreed. In its red brief, there was no argument that says this is not a structural error per 1105. So I think those are three reasons why harmlessness error doesn't apply in this case. But even if it does, I'm going to argue arguendo, just for the sake of it, that it's not going to be ever, well, I can't say ever, it's going to be very difficult to be harmless when a defense counsel is cut at the knees. His credibility is cut at the knees in the closing arguments by saying, no, that's not in evidence, when in fact it is. There are just too many constitutional rights at play, such as an impartial jury, such as having an effective closing argument, having your attorney making an effective closing argument. To do that, it just also kind of flies in the face of how we think of jurors evaluating credibility. They're supposed to be the fact finders. They're supposed to be the ones doing that. It also makes
Does it need to be addressed to the trial court in the first instance? In other words, if you read the statute, it says the expression, assuming that was an expression of opinion, is sufficient cause for new trial if
Right.
either party aggrieved thereby and interested desires it.
Yeah, I agree that specifically, that point, 1105, wasn't pointed out by defense counsel. However, defense counsel certainly in the moment objected, said, no, that was in evidence.
Mm-hmm.
Then thereafter closing, got up and said, I'm asking for a mistrial. And one of the reasons I'm asking for a mistrial is because that was in evidence, and then was renewed, I think, one more time on top of that. I think that's adequate preservation, considering the standards we usually have, which is, are you bringing to the attention of the court what you are asking for? And certainly was asking for a new trial here. Back to my list of things, reasons why, even if harmlessness analysis does apply, why this is not a harmless error. I think there's another point. The state agreed that it needed to prove a continuing course or scheme of conduct in this case. And this one kind of falling right in the middle of those three events could be seen as hollowing out the proof of a continual scheme or course of conduct. So those are both primary arguments for why it's structural and why, even if it's not structural, why the error is harmless. I can transition next to the next argument. Next argument has to do with the fact that there are the court's very statement in Fagone, which is whether prosecutors' conduct, any conduct, or judges' conduct, any conduct, might have prevented a witness from fully testifying is grounds for reversal. And in Webb v. Texas, that was the similar standard, very capacious, any conduct that could have prevented a witness from fully testifying. I realize that as...
Strout testified.
Yes, both of them testified, correct? Well, no, I'm sorry. Ms. Strout testified.
Yes.
Thank you, I misheard you. Ms. Strout testified. Mr. Simons did not testify. The error as to him is unpreserved. There was no objection at the time. There's certainly a long colloquy on the record, including the prosecutor putting on the record how he, another prosecutor, and at least two law enforcement officers went out into the hallway and said, we're not calling you. We've listened to your phone calls in jail. The implication being that we think you're lying, and we're no longer calling you. In addition, I think there needs to be an inference drawn that all the
But isn't that,
information...
when you start talking about that, I mean, at the same time, doesn't the witness Simmons have the right to be told, ooh, by the way, you could have a problem if you testify in this case, particularly if you testify along certain lines. I mean, what the Supreme Court, what the case law is aimed at is undue, essentially, pressure.
Undue.
And on the record, we don't know what was actually communicated to Simmons, do we?
Well, we know that one representation about what the conversation was. At least two police officers.
But isn't that a problem if we don't know what was actually communicated to him?
Well, I think you can infer from that when you have at least two police officers.
He should have been claiming his Fifth Amendment right and not testifying.
Perhaps, but that is a warning that should come, I think, just from the judge and maybe your own attorney. In fact, one of the cases that's cited in the briefing is the Thomas case. And the Thomas case is a federal Circuit Court of Appeals case. And I'm sorry, I don't remember which circuit court it was. But there, a judge had warned a witness, hey, maybe you need to go talk to a lawyer. Really, the way this ought to happen is you ought to be fully informed about the risks before you testify. The Circuit Court of Appeals said that's exactly what should happen. What happened next was gratuitous. It said, out in the hallway, taking a break, the potential witness could not find a lawyer and talked with a government agent, just one of them, not two of them, not three of them. And the agent said, yeah, you could be prosecuted for doing this. And the Circuit Court of Appeals said that's gratuitous. So I think following Webb and following Fagone closely, that's a very capacious standard, as I said. Any conduct that could drive someone off the stand. And that's what Thomas is applying there in this case. They're saying, well, it's gratuitous, it's extra, and it shouldn't happen. So I think it's very little that needs to happen from a judge, and certainly the defense counsel or the counsel for the witness can deliver that message.
Well, it's in my experience in the trial courts, it's fairly common in criminal cases for prosecutors and defense attorneys to advise the court that an unrepresented witness will be questioned on certain areas that may create some exposure, not involving the witness at this point. And what courts often do is arrange for an attorney to be available to counsel the witness on whether to invoke, and the court obviously wants to find out without the jury in the courtroom whether the witness is going to invoke their privilege.
I think that's best practice, and that is practice that happened here. It's what happened in addition to that. On the record, there were all kinds of representations about what will happen to Mrs. Strout and Mr. Simmons should they go ahead and testify. And then in addition to that, we have the meeting in the hallway between the prosecution and this witness without his attorney, which is problematic. I think
well, if the judge cannot find an attorney to represent the unrepresented witness with what the judge is told is potential exposure, is there anything wrong with the judge saying you have a right to avoid testifying in a way that might incriminate you, and you're going to be questioned, as I understand it, on the following areas, and you need to decide what you'd like to do?
Unless there's anything contextually odd about that, like that's the only witness, or it was said in a particularly slanted way, I don't think there's any problem with a judge saying something like that, a one-time deal. No, I don't think so.
Are you advocating for a rule of law that says if the state's attorney, the prosecutor, goes to the witness and said, you're going to be prosecuted because this is what we know about it, are you advocating for a rule of law that is never permissible?
Yeah, I think that needs to come through a witness's attorney if that happens. And I do think that is, in fact, not a new point that I'm advocating. It's perhaps a clearer statement of the existing law. Right. I think the prosecutor has a very impactful position as the agent of the state and the chief law enforcement officer in that particular case. And that message is going to come across in a particularly dissuasive way, I think, when it comes from the prosecutor.
We're actually on red.
Oh, there's the red light.
Red light, thank you.
I can see the timer.
Oh, okay.
I was like, we've gone past
I thought you were talking to Joel.
I kind of was. It's because I had a question to ask, and I was like, oh, there's no time.
May it please the court, counsel. First, I'd like to draw the court's attention to the fact that more so than in most cases, there's a very wide gulf between the appellant's statement of facts and the appellee's statement of facts. And I would encourage the court to directly go back to those points in the transcript, because there is a strong disagreement about what exactly the record shows as to each of these arguments. As to the objection at closing, this is reviewed for an abuse of discretion. There was no evidence that Jalbert claimed ownership of the Walmart bags specifically. There was evidence that Jalbert claimed ownership of the bags underneath his seat, and there was a hearsay statement that came in as from the defendant that indicated he brought the Walmart bags to the vehicle. But to the best of the state's recollection, there is nothing in the record that shows that Jalbert claimed ownership of the Walmart bags. And procedurally, what happened was exactly the bare minimum that is required by the rules. Parties are required to state the grounds of their objection succinctly. That does not make it a speaking objection. It just makes it minimally sufficient under the rules. The objection was objection arguing facts, not in evidence. The ruling was simply sustained, move on. There was no further discussion by the court on the record before the jury of this objection. The state cannot conceive how ruling on an objection standing alone could constitute a ruling, a comment on the weight of the evidence. It beggars what the appellant is asking here. Is it to prevent the state from having the ability to object during closing argument? Is it asking the court to simply refrain from ruling on objections by the state during closing argument? The state's certainly familiar with what a speaking objection was, and that was not what happened here, nor was there any comment. The case that was compared to in the brief was Edwards, and this is completely distinguishable from that kind of fact pattern. In Edwards, the court gave tons of information, including a detailed outline and a chronology and hard copies thereof to a jury to use in deliberations. Here, the court properly instructed the jury that you're the ultimate finders of what the evidence and facts showed. As to the defendant being prevented from calling witnesses, that's simply not true. Neither argument is preserved either, not Simmons nor Strout. Both are reviewed for obvious error. Strout is not preserved just because defense complained that Strout's attorney was going to get to talk to Strout before he was. There was no objection made. There was no ruling sought. That does not preserve a claim.
If I heard Attorney McNamara correctly, I believe he would advocate for a bright line rule of law that says that prosecutors cannot accost defense witnesses and with the threat of prosecution. What, if anything, is wrong with a bright line rule that says that?
Well, first off, that's not what happened here.
I'm just getting theoretical here. Just hypothetically, if as a prosecutor, would you be amenable to a rule that says you can't go to their witnesses and threaten them with prosecution?
Theoretically, that sounds reasonable. But again, that's arguing totally outside the record as to this case. The only thing the state would have done differently is perhaps physically drag Brother Toothaker into the hallway with us to be a party to the conversation as well. But the record is what it is. He was advised that both parties had listened to the phone communications and nobody was sponsoring him as a witness. The defense never attempted to call William Simmons as a witness during the trial. And in fact, the defense articulated lengthy reasons of valid trial strategy where it would not be in their best interest to attempt to call William Simmons as a witness at that point. Moving on to Sierra Strout. Again, her attorney was informed about a new pending investigation, of which the state knew limited information at that point. They were also informed that she was the girlfriend of the cooperator who already testified that he was selling drugs on behalf of the defendant, and that there was an outside possibility that she could inculpate herself in that offense. Her attorney spoke with her. Notwithstanding that, Ms. Strout testified anyway. And I feel like we would be having a different appeal on a different case had that not happened, because it would seem fundamentally unfair to allow Ms. Strout to take the stand and not advise her counsel of these potential areas of exposure for her before she chose to testify. There was nothing improper about those admonitions. There was nothing verbose or outside the realm of normalcy. The cases that the appellant cites as far as essentially tampering with a witness by over admonishing them. And Webb involved a lengthy and pointed admonishment with a direct threat from the judge to personally ensure that they got indicted and served years more in prison. In Fagone, there was detailed warning about specific crimes, penalties, and repeated that they could elect not to testify 3 different times from the court. In Morrison, there was an invalid subpoena issued to bring a witness to a prosecutor's office, not the court, so that that particular prosecutor could personally threaten them outside the presence of the court. In McCloskey, they told the witness attorney in advance that they'd be well advised to tell the client that they could be re-indicted if they testified. None of these are similar to what actually happened here. For starters, Simmons was never admonished by anybody in any way, shape, form, or fashion. His attorney was brought into the loop. His attorney indicated, as the record shows, that he was never able to even actually make contact with Mr. Simmons. And Mr. Simmons never came into the courtroom to ever get any kind of admonishment by the court because everybody decided they weren't calling him.
Is the tipping point on all of this? In State versus Fagone, we said that advising a witness is perfectly okay, but drove the line to emphasize the point that if the statements are threatening or intimidating, that crosses the line into the prohibited conduct.
I think that's exactly what this is about. Fagone acknowledges expressly that there is a competing interest in advising people like Sierra Strout.
And your point here is that the record does not arise to that level of threatening or intimidating.
Yes, Your Honor.
Well, aside from threatening or intimidating, do we have to find or conclude that remarks by either the state or by the judge effectively or could have effectively driven a witness off the stand? I mean, that's the language that we've used.
That is the language that was used. The state would argue here, as a point of fact, nothing deterred her from testifying. She did, in fact, testify.
Well, and Strout, there may be a distinction between Simmons and Strout for that reason, because Strout did, in fact, testify, right?
Correct.
Okay. And so in order to find a violation, is it your position that somehow with Simmons it would have to be proven that it was, first of all, remarks of either the state or the judge, for that matter, that kept Simmons indeed off the stand?
Improper remarks from one or the other, because again, based on Fagone, that witness, Mr. Simmons.
And the first step, I guess I'm thinking of it as sort of two steps. That it
Okay.
has to be remarks from either the prosecutor or the judge, as opposed to his own attorney. And that second of all, they had to be improper remarks.
I would agree with that, Your Honor.
Okay.
And by improper, do you mean threatening or intimidating?
I think so, Your Honor.
Or is it beyond that?
At least unduly threatening and intimidating, which has been explored by these various other cases. And again, we don't even meet the first step of Madam Chief Justice's test, because there were no statements or remarks made by the court or the prosecutor to Mr. Simmons.
Or by government agents of the prosecutor?
Or by agents of the prosecutor. There is nothing in the record to suggest that at all.
And that goes back to what I said at the beginning, that we don't know exactly what was said to Mr. Simmons.
We have what is in the record, Your Honor, and I don't want to argue outside the record. And likewise, I do not think it's proper for appellant to invite the court to take on a fact-finding role and attempt to generate some sort of inference from what's in the record. It just amounts to arguing outside the record.
There don't appear to be additional questions.
Thank you, Your Honor.
Thank you. I'd like to switch back to the first assignment of error.
But I'd like to keep going on that one for a moment.
Great, thank you. What's your question?
Well, it was the question I actually was going to ask. So with regard to Ms. Strout, who did indeed testify, I mean, there is nothing on the record to suggest that she was effectively driven off the stand, or indeed that her testimony was changed as a result of any comments made, never mind whether those comments were improper.
I'll concede that. And I think also the only possible response to that is that defense counsel was talking up her testimony before that, and it didn't seem to live up to the expectations that I was expecting as the reader of that. But other than that, I concede that point.
Okay, thank you.
So where in the record is the threatening and the intimidation of Simmons?
To Simmons, I have the notes here. To Simmons, So there's
that were actually communicated to him as reflected in the record?
One, in the hallway, there's two officers, at least two officers, and the prosecutor. This is at page A61, so 61 of the appendix, going out there and saying, we have listened to your phone calls and we're not calling you as a witness anymore. I think there's only...
Is that incorrect?
Is that incorrect? That's
Or
the
improper?
representation of the prosecutor.
Is that improper if that's what was said?
I do think that there's a potential for that to be improper. I think telling you we're not calling you because we think you're going to lie is probably going to shade somebody's testimony. If you want to conform and not be prosecuted for perjury, you're going to, certainly any reasonable person is going to back away from
But what
how
you
they're
started
going
off
to
by saying
testify.
is not, that's not what it was. It was, if we've listened to your phone calls, giving the preference
Right.
of that.
And I think from defense standpoint, that it's certainly possible that the proffer that the state received was the incorrect version, and that whatever they heard via the phone calls was going to be the correct version. And in fact, that's what should have been left for the jurors to decide, but he wasn't called at all.
Counsel, can I ask you, do you, there was a representation that that the record does not establish that Jalbert claimed ownership of the Walmart bag. Do you agree with that?
That Jalbert himself did not say, I own that Walmart bag. Correct. That came from the defendant, that statement, that so-called hearsay statement that was admitted in evidence. That's at page 215 and 172/173. There's another, it's touched on as well. But I think that goes to my point. I do agree that there's a gulf in readings of the facts between the two briefs. And I think the state simply misheard the argument that defense counsel was actually making and objected to something that he thought he was hearing. If I, Your Honor, may finish this thought briefly, I'd appreciate it.
Go ahead.
All right, thank you. And that changed the effect. And we see that now in the briefs, where there seems to be this reading by the state that no, defense counsel was actually saying that Jalbert had made those statements. But that is not clearly from the transcript what is being said. What's being said is there were statements in evidence that Jalbert owned those drugs. And if there was any question about that, that's exactly why such objection should be handled at sidebar and not ruled on by a judge who lacks independent memory, as he later said, in a conclusive and binding way in front of the jury. Thank you.
Thank you, counsel. As is our usual practice, we will, of course, take the matter under advisement and issue a written decision in due course. And with that, I believe we are done for the day.